Conventions on patents. This is being organized on the occasion of World Intellectual Property Day 2022. And for this program, we have three esteemed guests who are with us. We welcome Ms. Aisha Bhattacharya, Mr. Kim, and Ms. Tomoko for this program. So let me introduce the guests to you who are highly experienced, knowledgeable. So let me begin with Ms. Aisha Bhattacharya. She is a fellow with the Patents and Treaties Law Section, Patent and Technology Law Division at the World Intellectual Property Organization, WIPO, Switzerland, which is the UN specialized agency and global forum for intellectual property services and policy. At WIPO, she has contributed towards the organization's strategic goals concerning the balanced evolution of the international normative framework in the area of patents and technology. By doing in-depth research in these areas of law, preparing related reports, and providing secretarial services for organization of international conferences of the division. Ms. Aisha pursued her undergraduate degree in law from Jindal Global Law School, India. She is an advocate enrolled with the Bar Council of India and has worked in the areas of IP law and commercial litigation, arbitration at Cyril Amarchand Mangaldas, one of the leading law firms of India. She acquired her Master of Law degree from the University of Cambridge with a specialization in IP laws. Her interests lie in the practical, regulatory, and theoretical aspects of IP laws. We welcome you, Ms. Aisha, for the webinar. Now, I would like to introduce Ms. Tomoko Miyamoto, who is the head of the Patents and Treaties Law Section, Patent and Technology Law Division in the World Intellectual Property Organization, the same organization, WIPO. She joined WIPO in 1997 and has worked on various issues regarding intellectual property. In particular, she has wide-ranged experience with respect to patent policy, law and practices, including normative development of the international patent system, promotion of patent-related treaties, legislative and legal advice to member states, and provision of training in the area of patents. Areas of her responsibility also cover trade secret protection. Prior to joining WIPO, Ms. Miyamoto worked for the Japan Patent Office. She holds a master's degree in electronics engineering and an LLM on IP law and management. We would like to welcome Ms. Tomoko to the webinar. Now, our third guest is Mr. Taigun Kim. Hope I have pronounced it right. A national of the Republic of Korea, is currently a legal officer at the PCT Legal and User Relations Divisions of the World Intellectual Property Organization. His main duties includes working on development of the PCT system, providing legal assistance, and performing outreach activities. His expertise lies mainly in legislations and treaties related to patent, as well as international cooperation in the field of intellectual property. Before taking the current post in 2017, he had worked for the Korean Intellectual Property Office from 2002. At KIPO, he served as a substantive patent examiner, an international cooperation officer, an officer in charge of PCT International Affairs, and an administrative judge at the Intellectual Property Trial and Appeal Board. He also worked as a consultant at the Technical Assistant Bureau for the Asia and the Pacific of WIPO from 2007 to 2009. Mr. Kim is a registered patent attorney in the Republic of Korea and holds a bachelor's degree in electrical engineering from Seoul National University. He has authored numerous publications on intellectual property, among which are Interpretation of the TRIPS Agreement, Practical Guide for Utility Model Examiners, and PCT International Search and Preliminary Examination Manual for KIPO examiners. So, by understanding the profiles of these guests, we can understand their experience, their knowledge in the field. And on this occasion of World Intellectual Property Day 2022, we heartily welcome all the participants, who include students as well as professionals, and we hope they get the insights from these three eminent guests. So the floor is towards the guests today. So I welcome you all once again to the webinar. Hope you enjoy, you gain much information, and you get maximum benefit from this webinar. For any questions and answers, we will handle it in the last 15 minutes of the session. So I request all the three guests to begin the webinar. Thank you so much.
Thank you very much. And on behalf of the WIPO colleagues, I would like to thank the CII and ISERD for inviting us to join this celebration of the World IP Day today. Happy IP Days to all. And we're very honored to have been invited to such a distinctive meeting today. And I know that it's a very late hours now in India, and was very impressed by the number of participants who are joining to this webinar. So today's webinar, I and Sayesha is going to first talk about the Paris Convention and the Budapest Treaty. And then Mr. Kim Tae-gun is going to talk about the in-depth on the PCT, Patent Cooperation Treaty. So let me start with my slides with the presentation of the Paris Convention and the Budapest Treaty. So before diving into each treaty, I would like to just show this slide. WIPO administers all in all 26 treaties, and among them there are 5 patent-related treaty: the Paris Convention, PCT, Budapest Treaty. These are the 3 treaties that we're talking about today. But in addition, there are the Strasbourg Agreement, which relates to the IPC, International Patent Classification, and also the Patent Law Treaty, which is the latest treaty in the field of patent, PLT, adopted in year 2000, that relates to the formality requirements under the patent procedures. So just to sort of go back a little bit, since we're talking about the international IP norm today, the question is, why do we have international IP norm? What is the function of these international IP norms? The IP norms can have a different phases, but mainly, I don't think these are the exhaustive list, but in many of them, they promote international legal certainty and fairness among the member states and the users of the IP system for obtaining the patent or obtaining the IP or enforcing the intellectual property. Removing inadequate barriers for obtaining and enforcing IP rights internationally through either the harmonization of national laws, establishing international systems, or even mutually recognizing certain process or certain actions among multiple countries. Then, particularly in the area of patent, improving access to patent information is also one of the functions carried out by the international IP norms. For example, like as I said, international patent classification. This is part of the international standard. WIPO also have some other standards relating to patent document, which facilitate people all over the world to access to the patent information through the standardized forms and standardized format. And the more the world is getting digitalized, this kind of standard format is getting more and more important in my view. I just would like to add that these international norms, none of them had established or regulates everything in the patent system. So there is always certain flexibilities in the international norms. So when the national countries, the member states of WIPO or the contracting party of those treaties implement these international norms, there are certain flexibilities, and the one level, the higher level, could be what is in the treaty, but then there is always the implementation of these treaties using the flexibility embedded in the international norms. So for that reason, when I am presenting the Paris Convention and Budapest Treaty, I will kick out with what we can find in the international treaty. And then my colleague Sayesha is going to deep dive into the national implementation in India and how these treaties are actually implemented in the Indian law. So with that, let me start with the introduction of the Paris Convention for the Protection of Industrial Property. The story goes back to the time of towards the end of the 19th century, where the Industrial Revolution was up to speed. And this certainly accelerates international exchange of goods, but at the same time, it accelerates the movement of people, the movement of business people, movement of engineers, movement of experts in the technology as well. And that certainly would, in a way, facilitate the copying of inventions and goods, which the knowledge they acquired in foreign countries, bringing back to their country, and then produce the same product or using the same process. There was and of course, the industrialization. This means it is more easier to replicate the same kind of industrial product in a massive scale, which was not possible before when the artisanal was producing each and every good using their skills in the hands. So the time goes back to 1873 when there was an international exhibition on the various inventions and the new technologies in Vienna. Of course, at that time, it was the Austrian-Hungarian government who was organizing this exhibition, but many foreign technology holders, let's put it in this way, they were very reluctant to participate in this international exhibition. The reason is because if they thought if they bring their new technology and show it in this international exhibitions, people around the world would have a look at it, they will learn what it is, and then they will simply copy their invention. Or if they show their invention in Austria-Hungary, then it will be copied in Austria and Hungary, which has a good level of technology. So that was obviously, it was a bit of unsatisfactory for the organizers of this international exhibition, of course, as well. And there was the sentiment that we probably need to have some kind of international rules that makes people more comfortable to show their inventions, but at the same time, protect those inventions at the international level. And that leads to the conclusion of the Paris Convention for the Protection of Industrial Property in 1883. As the title of this treaty suggests, the Paris Convention covers all area of industrial property, not just patent, but it also covers trademark, industrial design, and all areas of industrial property. And in fact, that is the very first international treaty in the area of intellectual property. After a couple of years later, there is a Berne Convention, which deals with the copyright, was adopted. So that is this 1880s. This is really the time in, at least in the IP area, where the awareness about the protections at the international level had emerged. Today, there are 178 countries which are members of the Paris Convention. And as you can see on this map, it's almost blue. There are really a few countries, particularly in small island countries in Pacific, that are not member of this convention, but mostly the majority of the countries are already the member of the Paris Convention. So let me go into a little bit more specific elements or the issues that are addressed in the Paris Convention. The first area relating to the Paris Convention is the principles regarding protection of industrial property. As being the very first international convention, it set up very important principles that are still valid today. The first of all, the first is a national treatment, meaning that the same protection and legal remedy shall be provided for the nationals and the foreigners who seek patent protection in that country in principle. Now, why is it in principle? Because the Paris Convention also provides explicit reservations on certain aspects, which are the judicial and administrative procedures, jurisdictions, designation of address for service, and appointment of agents. So for those areas, it is permissible not to provide the national treatment. Then another principle which is widely used today is a right of priority. I think for the audience of this webinar, I do not need to explain what it is. This is something that is used as a matter of fact today, I think. Then there is another provision relating to the independence of patents. And here the Paris Convention explicitly states that the grant of patent or the revocation patent on same inventions in different countries are independent from each other. So the grant of one country on certain invention can be independent from the decision of whether to patent or not in another country. These are independent. Another interesting principle found in the Paris Convention is the case where there is a restriction of sale on a certain invention under the national law. For example, when we think about the pharmaceutical products, unless the pharmaceutical products meet certain safety and efficacy, which has to be approved by usually the Ministry of Health, those products cannot be sold in the market. However, this provision said, even in those cases, the patent shall not be refused or invalidated just because those patented products are restricted from the sale in that domestic law. So these are the two. One is the grant of the patent, and another issue is the restriction of sale by law for various reasons. Another areas of provisions that we can find in the Paris Convention is a certain substantive rules that must be applied by member state. There are not too many. It is rather, let's say, the minimum number of provisions that we can find in the Paris Convention in the field of patents. So the first is the right of the inventor to be mentioned in the patent application. The inventor can also renounce their right and can ask not to be mentioned, but they do have the right to be mentioned in the patent. There is also the provision, Article 5, in relation to the compulsory licenses and forfeiture of patents. In the Paris Convention, it refers to the two grounds for the grant of the compulsory license. One is a case where there is an abuse of the abuse from the exclusive right. And another case is where the patentee failed to work the patented invention, or there is an insufficient work of patented invention by the patentee. So in these specific two cases, there is two types of provisions. One is in the case of abuse, the country has the right to grant a compulsory license. So this is clearly stated there. However, there should not be the forfeiture of patent before expiration of the 2 years from the grant of the first compulsory license. That means the countries cannot simply fortify the patent, that there should be a step. First, there is a compulsory license, and then it does not kind of resolves the problems, then there may be the possibility of the forfeiture. In the case of the grounds of failure to work or insufficient work, the forfeiture, I think here I missed something here. The forfeiture of the patent shall not be made, the compulsory license should be refused if a patentee justifies with a legitimate reason, and also the compulsory license should be non-exclusive and non-transferable unless it goes together with the business of the licensee of the compulsory license. Another provision relates to the exceptions to patent rights for devices forming part of vessels, aircraft, or land vehicles, which temporarily enter into the country. Now, there is a possibility where the patent can be patented invention can be used in those transportation means, and those transportation means necessarily enter into foreign countries' territory, either temporarily or accidentally. And in those cases, there should not be the infringement of the patent, even if a patent is granted in those foreign territories. Then finally, there's a temporary protection at a certain in the case of temporary protections at the official or officially recognized international exhibition is stipulated in Article 11. This is kind of curious because the starting point of the Paris Convention was this fear of the people or of being their invention to be copied and not to present them in the international exhibitions. But so of course, the Paris Convention discussed these questions about the protection of inventions at international exhibitions, but they did not agree with the complete set of solution for that. So what they could agree and the countries could still agree until today is that there should be a temporary protection, but there is no stipulation of what kind of temporary protection should be given, how long it should be given. Those questions are all open, and they are all decided in the national legislation. So just to highlight, the Paris Convention continued to be relevant and significant in today's intellectual property law. It basically lays down the universal fundamental principles, which are continue to be relevant and they are continue to be used. It only stipulates the minimum substantive rules, as I showed, but it encourages further development of international norms between countries by explicitly allowing or encouraging the countries to make special agreements, as long as those agreements do not contravene the provision of the Paris Conventions. And therefore, the Paris Convention has become a kind of a gateway to other treaties. And the Budapest Treaty or the PCT, they are, in a way, the special agreements under the Paris Convention. So the membership of Budapest Treaty or the membership of the PCT has to be the members of the PCT, members of the Paris Convention. And finally, there is another international treaty administered by the World Trade Organization, the TRIPS agreement. This TRIPS agreement also obliges WTO members to comply with the substantive provision of the Paris Convention. So that means the Paris Convention also applies to the WTO members that are not the Paris member states. They are not many, as I have shown in the map, but still there is, the Paris Convention is in a way, part of the TRIPS agreement, and the provisions of the Paris Convention is continued to be in life through the TRIPS agreement as well. So I stop here, and then I'm going to pass the floor to Sayesha, and she's going to talk about how those provisions are implemented in India.
Thank you, Tomoko. Good evening to everyone in India from here in Geneva. My name is Saisha Bhattacharya, and I work as a fellow with the Patents and Treaties Law section here at the World Intellectual Property Organization. It is a privilege for me to be addressing this event today, organized by such eminent organizations of my country. I would be giving you more information on the Indian implementation of two major patent law international treaties, the first one being the Paris Convention. I will start with the Paris Convention's implementation in the Indian patent law, but before that, it is important to actually look at the basic timeline of events with respect to the important international patent law treaties and India's signing of the same. So first came the Paris Convention in 1883. Then in 1970, it was for the first time that the India's Patent Act of 1911 was revised for the first time, majorly post the independence of the country. Then in 1994, the Agreement on Trade-Related Aspects of intellectual property rights came into being, which is the TRIPS agreement. And finally, on 7th of December 1998, the Paris Convention was signed by India. Next slide, please. Tomoko, next slide, please. I'll just be back in 1 second.
Excuse me, I think I'm going to let me close it again.
Sure.
And then reopen it.
Sure. Thank you. That's perfect. Thank you.
Good. You're muted, Sayesha.
Sorry, thank you. So going into the actual implementation of the treaty, India actually did not have to make many changes at all to the Patents Act of 1970 in order to accede to the Paris Convention. Nevertheless, I will discuss a couple of areas of the Indian patent law to show how it is actually in line with the Paris Convention. So the areas that I will specifically cover is national treatment, right of priority, mention of the inventor in the patent, compulsory licensing, and temporary protection at certain international exhibitions. And we will now see how these aspects of the Paris Convention are actually covered by the Indian patent law regime, which is mainly the Patents Act of 1970. Next slide, please. The slide before this, Tomoko. Okay, so maybe I will just go ahead and share my own screen. Maybe that will be easier.
Now
Yeah.
it works?
Yeah, I think I'll do this.
Mm-hmm.
Yeah. So. Okay, perfect. So national treatment is the first area that I'll be dealing with. So national treatment was basically covered by the Paris Convention in Articles 2 and 3. India's patent law basically provides for national treatment as no distinction is actually made between Indian nationals and foreigners. So for example, if I consider a national of country X, and let us say that this person basically applies for a grant of a patent in India, according to the Paris Convention and Indian patent law, which is also in line with the Paris Convention, the Indian Patent Office shall apply the same norms and rules to this applicant from country X as would be applicable to any other Indian applicant as well. And similarly, once this patent has been granted, the applicant from X shall have the same protection after grant and identical legal remedies also against any infringement proceedings. So the next area that I will basically be dealing with is the right of priority. This is basically dealt with in Article 4 of the Paris Convention. And the Paris Convention, according to this article, basically states that there are 12 months time that a person has to file the patent application in the member countries from the date of filing of the earliest application. So Section 135 of the Indian Patents Act basically deals with these convention applications. And the section says that a convention patent application can be filed in India under this particular section by taking priority from an earlier patent application filed in a convention country. Similarly, the convention patent application can also be filed with the Indian Patent Office within 12 months of filing a priority patent application in a foreign country. If there are multiple international patent applications, then the convention patent application has to be filed in India within 12 months of the earliest priority date. And Section 136 of the Patents Act basically lays down certain special procedural requirements for convention patent applications in India. Now, the next area that I'll be looking at is mention of the inventor in the patent. Now, the Paris Convention states that the inventor shall have the right to be mentioned as such in the patent. Now, Rule 74 of the patents rules in India basically states that a patent shall be in the form as specified in the third schedule with such modifications as the circumstances of each case may require. And as you can see on the slide, if there is basically the third schedule, there is a form of the patent which is basically being given in this third schedule. And it basically mentions that the inventor's name needs to be there, as I've marked in the slide. And Section 28 of the Patents Act basically states that if you are an inventor and you have actually made substantial contribution to the invention, then even at a later date, subject to other conditions of the section, your name can be added as an inventor if a request for the same is made accordingly. Now, compulsory licensing is a very important aspect of Indian patent law, and it is actually something which is covered by Article 5A of the Paris Convention. And in the Paris Convention, it has been stated that a compulsory license based on failure to work or insufficient working of the patented invention may only be granted pursuant to a request filed after 3 years from the grant of the patent or 4 years from the filing of the date of the patent application. And it can be refused as well, this application for compulsory licensing, if the patentee gives legitimate reasons to justify this inaction. So India's Patent Act has actually an entire chapter which deals with compulsory licensing, and the most important provision of the same is Section 84. And Section 84 of the Patents Act basically states that at any time after the expiration of 3 years from the date of grant of a patent, any person interested may make an application to the controller for the grant of compulsory license on patent on any of the following grounds. There could be reasonable requirements of the public which have not been satisfied, or the patented invention is not available to the public at a reasonably affordable price, or the patented invention has not been worked in the territory of India. An application for a grant of compulsory license can be made by any person interested, including the license holder as well. And the application needs to contain a statement setting out the nature of the applicant's interest, together with prescribed particulars and the facts upon which the application is based. So this is how compulsory licensing is more or less dealt with in India. There are some other relevant provisions also, which are very important to the compulsory licensing regime in India. For example, as we can see in this diagram, there is Section 84(7) of the Indian Patents Act. It deals with the reasonable requirements of the public which are deemed not to have been satisfied in order to grant a compulsory license. Further, there is Section 84 subsection 6, which lays down the factors which the controller ought to take into account while considering an application for a compulsory license. And all the other relevant sections in the compulsory licensing chapter of the Patents Act is actually laid down in this diagram. And for paucity of time, I don't think I'm going to delve deeply into each of them. However, they're quite straightforward. And if you're interested, you can look at them at your leisure time. So the final area that I will basically be dealing with is temporary protection at certain international exhibitions. This is something, as Tomoko mentioned, is covered by Article 11 of the Paris Convention, and the countries of the Paris Union, as has been held in the Paris Convention, in conformity with their domestic legislation, can grant temporary protection to patentable inventions in respect of goods which are exhibited at official or officially recognized international exhibitions held in the territory of any of them. So this is kind of like a grace period which has been provided by Paris Union countries and by virtue of this provision. Now, Section 31 of the Patents Act in India basically deals with this grace period or this temporary protection, which is there in the Paris Convention. In India, actually, any public display or use of the invention by the inventor or with the inventor's consent amounts to anticipation of the invention and hence results in lack of novelty. Now, if there's no novelty in a patent application, such a patent application, as you would be very well aware, would not be allowed by the Indian Patent Office. However, this section actually provides for a grace period in line with this Article 11 of the Paris Convention, and it states that the public display, publication, or use of an invention claimed in a complete specification in an exhibition is not considered anticipation, provided that number one, the said exhibition has been notified by the central government in the official gazette of India. And secondly, a patent application is actually filed within 1 year after the opening of the exhibition or the reading or publication of the paper, as the case may be. So now I would like to give the floor back to Tomoko to discuss the next relevant international treaty, that is the Budapest Treaty.
Thank you, Sayesha, for giving me the floor again. And if you may, could you please continue to
Of course,
move your slides? Thank you.
Sure.
So the next, we're talking about the Budapest Treaty on the international recognition of the deposit of microorganisms for the purposes of patent procedure. This is the official name of the Budapest Treaty. And in this long title, there are 3 elements which kind of illustrate what this treaty is about. So it is about the international recognition, it is about the deposit of microorganisms, and it is relating to the patent procedure. So these are, in a way, the keywords that describe this treaty. Next slide, please. Now, the background of the Budapest Treaty, let me talk about this. Now, as you all know, the invention must comply with the patentary requirement in order to obtain a patent protection. And one of those patentability requirement is a sufficiency of disclosure, meaning that an invention must be described by the applicant in sufficient detail or sufficiently clear and complete for a skilled person to carry out the invention. Now, the thing is, if an invention uses a new microorganism or the invention is concerned a new microorganism which is not yet publicly available, then it might be difficult to fully disclose these inventions in a written form in a patent application. And somehow the way to solve this problem is a deposit of microorganism to a culture collection to complement the limited possibility of written disclosure of this invention. Next slide, please. Now, by 1970s, many national laws started to require the deposit of microorganisms in culture collections in case where an invention uses or it concerns a new microorganisms not disclosed to the public or it's not being able to obtain publicly. However, since there was no international rule, there are a variety of national laws relating to the deposit of microorganisms. Each patent office designate a different cultural collections that the applicant has to deposit their microorganisms. So when the patent applicant is seeking patent protection in different countries, they may need to deposit the same microorganisms in several cultural collections in different countries. And this is, of course, very complex and it can be very costly. So the next slide, please. So in order to streamline the cost effectiveness of the deposit, the Budapest Treaty was created or was adopted in 1977. And currently there are 86 contracting states. And these are shown in blue in this map. But in fact, the effect of the Budapest Treaty can be a little bit more broader because there are three regional patent offices, ARIPO in Africa, EAPO in Eurasian countries, and EPO in Europe. They also declared the acceptance of the recognition of the Budapest Treaty for the purpose of the regional patent procedures, for the regional patent grant. And therefore, in a way, also those patent procedures in those regions are also covered by the Budapest Treaty. Next slide, please. Now, the main feature of the Budapest Treaty is as follows. So what the treaty does is, under this treaty, there are certain cultural collections recognized as international depository authorities, IDAs. And a contracting party to this treaty has to recognize, for the purpose of their patent procedure, the deposit of a microorganism which was made with any of the IDAs, whether these IDAs are in their territory or they are in abroad. So the deposit made in any of the IDAs has to be recognized by the member states of the Budapest Treaty for the purpose of meeting the sufficiency of disclosure. Now, a small note is that the Budapest Treaty only requires a contracting party to recognize the effect of the IDA deposit. So conversely, a contracting party may allow deposit of microorganisms to cultural collections other than IDAs under its national law. So the treaty does not limit the possibility of each countries to specify the depository depository institutions that the applicant has to deposit, but at least they need to recognize the effect of the deposits that are made in the IDA. Next slide, please. Now, what is the IDA, International Depository Authority? So they are a cultural collection, and it has to be located on the territory of a contracting state, meaning a member state of the treaty, and it must fulfill the requirements stipulated under the treaty and the regulations. And what they do is basically they accept the deposit of microorganisms. They issue the receipt of the deposit. They storage the deposited microorganisms, and then as necessary, furnish the samples of deposited microorganisms. And in order to obtain the status of an IDA, there must be a formal nomination by the contracting state in which this cultural collection locates. And the country in which this cultural collection locates has to give the assurance that this collection complies, and they will continue to comply with the requirements of the treaty and the regulations. So it is not the, let's say, it's not that you can raise your hand and then become the International Depository Authority, but there are certain requirements, and there need to be a certain steps to be made involving the government of that culture collection. And as a small note again, the IDA, they accept the deposit of microorganisms, but in order to storage them and furnishing the samples, keeping them alive, they need to have certain facilities. And therefore, an IDA often accepts only certain kinds of microorganisms, and which they could handle within their facilities. Next slide, please. Yes, I do not go into the details of this slide. This is just to illustrate a different kind of requirements that are stipulated in the Budapest Treaty in order to become a depository, or become the International Depository Authorities. So in addition to some technical issues, there are also more general requirements, such as they should be impartial and objective, or they should be available to any depositor under the same conditions, and so on, to function as an international function. Next slide, please. The IDAs, of course, they have to have the expertise and facilities to keep the microorganisms viable and uncontaminated. And then they must provide the sufficient safety measures to minimize the risk of losing the deposited microorganisms. And in case that sometimes there could be accidentally, that could be dead or lost, whatever, then there is a mechanism for the applicant to make a new deposit to the IDAs. And then there is also a certain mechanisms, for example, like if the IDA stop their function as an depository institution under the Budapest Treaty, then there is a procedures in the treaty that that makes it possible to transfer the deposit of the microorganisms to another international depository authorities. Next slide, please. The storage of course, in order to keep it available, the IDA has to store those microorganisms alive, and they have to keep them at least 5 years after the most recent request for the furnishing of a sample of the deposited microorganisms, and in any case for a period of at least 30 years after the date of the deposit, whichever is later. And so that means it's quite a long time. The IDAs has to at least keep those deposited microorganisms for 30 years. A footnote, small footnote, is that the Budapest Treaty does not provide a time limit for depositing the microorganism for the purpose of patent procedures. The treaty does not say that the applicant has to deposit microorganisms before filing a patent application, or after, or within certain months. Those are not stipulated in the Budapest Treaty. Yes, maybe next slide, please, for the sake of our time. And then, since the deposit is part of the disclosure of the patented disclosure of the invention in the patent system, where necessary, these deposited materials, the deposited microorganisms, the IDAs has to furnish a sample to the requester of the sample. And there are possibility of the different type of institutions where to whom the samples may be furnished. The first is to any interested industrial property office. Usually the industrial property office does not test the invention by themselves by getting the actual microorganisms. So it's rare, if not none, but this does not occur very often. And then the furnishing of the sample to the depositor or third parties authorized by the depositor. This is another case. And the third case is the samples to any parties legally entitled under the applicable law. So again, here, who will be legally entitled persons other than the depositor or a third party authorized by the depositor is decided in the national law of each country. Yes, next slide, please. So there are 48 such IDAs all over the world in 26 countries. And on the map, the countries that shows IDA, these are the countries that has one or more international depository authorities in their countries. Next slide, please. Now, finally, a little bit about the terminology. So as I have been saying, the Budapest Treaty also in its title talk about the microorganisms, deposit of microorganisms, but this is mostly because the state of the art at the time when this treaty was negotiated and adopted, it was all about microorganisms. But since then, clearly the biotechnology has advanced and developed. So there are other kind of biological materials which might need to be deposited in order to complement the written disclosure of the invention. And therefore, some IDAs, they also accept not only, so to speak, scientifically defined microorganisms, but also they accept, for example, eukaryotic DNA, plasmids, hybridomas, seeds, etc., etc. And this comes together with a technological development, but in reality or in practice, it is very cumbersome to change or to amend the international treaty itself. There is a very heavy process for amending the international treaty. So the Budapest Treaty continued to use the microorganisms, and there is no definition of the term microorganisms in the treaty, but in reality, the many national laws and in practice, what we are talking about is actually the depositive of biological material, which from the scientific point of view, it goes a little bit beyond the microorganisms. So I think that would be the end of my slide. Oh no, there is a last slide. So this is just a wrap up what the Budapest is not and what Budapest is. So the treaty is not about the substantive patent law and the patentability requirements, and it is not about when the deposit has to be made or who are legally entitled to obtain a sample. But more, the Budapest Treaty is about the trying to eliminate the needs of multiple deposit of microorganisms in various countries through the recognition of the deposit in the IDAs, and it provides the procedures of how to acquire the status of IDA, how to terminate the status of IDA, as well as how the procedures to carry out, the procedures that are carried out by the IDAs, like receiving deposits, storage, furnishing of samples, and so on. So I think this is really my last slide, and I will pass the floor to you, Seisha.
Thank you, Tomoko. So now discussing the implementation of the Budapest Treaty in India. There is again this timeline which becomes relevant. In 1977, the Budapest Treaty was the Budapest Treaty basically came into being, and it was on 17th of December 2001 that India basically signed this particular treaty. Yeah. So now discussing the implementation of the Budapest Treaty in India. There is a mechanism which has been provided for in the Patent Act in India for depositing biological material in internationally recognized depository authorities, which are the IDAs, for the purposes of supplementing the description of a specification. And section 10.4.2 of the Patents Act basically specifically deals with this. It says that in case a biological material described in the specification of an application is A, not available to the public, or it is not or cannot be described adequately as per the provisions of the Act, then such a material will have to be deposited with an international depository authority, that is an IDA, under the Budapest Treaty. Then there is section 10.4.2a of the Patents Act, and this states that this particular deposit of the biological material needs to be done on or before the date of filing of the patent. Then section 10.4.2a of the Patents Act, read with rule 13.8 of the Patent Rules of India, states that the period within which the reference to the deposit shall be made in the specification mentioning a biological material shall be 3 months from the date of filing of the application. And finally, section 10.4.2b and d of the Patents Act basically lays down certain requirements of the specification where such a biological material has been mentioned. So what all needs to be included in the description of such a specification? The name and address of the IDA needs to be mentioned. The date and number of the deposit of the material at the IDA needs to be mentioned. The source and geographical origin of the biological material in the specification needs to be mentioned when all of this is used in an invention. So what is the conclusion of this slide? That the invention, if being applied in India, uses a biological material which is new, and it is essential to deposit the same in the international depository authorities, which are laid down under the Budapest Treaty. And this has to be done before the filing date of the patent application in India in order to supplement the description. Now, another aspect and very important task of an IDA that was also mentioned by Tomoko is that it furnishes samples of the biological material. And according to section 10.4.2c of the Patents Act in India, what does the IDAs according to the Patents Act do? The access to the samples is available in the depository institution only after the date of application of the patent in India, or if a priority is claimed, then after the date of priority. Now I will quickly go through some information on the international depository authorities in India. There are actually 3 recognized international depository authorities in India. The first one is the Microbial Type Culture Collection and Gene Bank, which is MTCC, and it acquired the IDA status on 4th of October of 2002. The kind of material accepted by this particular IDA and its schedule of fees and detailed procedure followed by the IDA is given in the link, and I've put the link on the slide. Further, the second IDA in India is Microbial Culture Collection, MCC. It acquired the IDA status on 9th of April 2011. Again, information about it is on the link on the slides. And finally, the third one, which is the latest IDA to actually join the list of recognized IDAs under the Budapest Treaty from India, is the National Agriculturally Important Microbial Culture Collection, NAIMCC, and it very recently on 28th of July 2020 acquired its IDA status. So as already mentioned in the previous slides, all the information that I have discussed up till now, such as the implementation of the Budapest Treaty by Indian patent law and IP offices, and specific procedural requirements of individual IDAs in India, all of this can be found on our WIPO website. And there's actually a special guide which has been prepared by our colleagues for the Budapest Treaty. And I've also provided the link to the same on this slide. So if you're more interested to delve deeper, then please feel free to access this website and make use of these resources. Now, I will quickly deal with some statistical data concerning the Budapest Treaty and its implementation in India. So this graph, as you can see here, shows the total number of deposits which have been made with all the IDAs under the Budapest Treaty between 2008 and 2020. And as we can see from this graph, there has been a gradual increase in the deposits with the IDAs over the years. This other diagram shows basically the position of India in relation with deposits of microorganisms in 2020. And it shows that India is actually amongst the top 10 countries in the world in terms of microorganisms deposited in 2020. And the exact number of microorganisms deposited in the Indian IBAs was around 80. And the top three countries with regard to deposit of microorganisms is China, United States of America, and the Republic of Korea. This final pair of graphs basically shows the total number of deposits made and samples furnished by two specific IDAs in India, the Microbial Culture Collection, MCC, and the Microbial Type Culture Collection and Gene Bank, MTCC. And since the third IDA, that is NAI-MCC, received its IDA status just a year back, we don't really have enough statistics for that particular IDA. But some observations that can be made from these two graphs would be that 2018 and 2019 seem to be very good years in terms of the number of deposits made at both the IDAs, and the combined deposits which were made were actually more than 100 for each of these years. However, for the year 2020, as you can see, all the deposits were actually made at MTCC and no deposit was actually made at MCC. And cumulatively, the total number of deposits were actually only 80. And that is much less than the cumulative number of deposits made in 2018 and 2019. And probably this fall in the number of deposits made was because of the pandemic, wherein it was not very easy for deposits to be made and stored at the IDAs. So with that, our presentation comes to an end. And thank you so much for your patience, for bearing with us. And we would be more than happy to address any questions that the audience may now have. Thank you.
Hello. Can you hear me?
Yes, we do hear you.
Yeah. So I see that India now has 3 centers for collections of the deposits. Okay. So just going by the geographical location, for one center is in Pune, another one is in Chandigarh, and the newest one is in Uttar Pradesh in Mau. So you have 2 centers in North India, one is in West India. So the South India and the East India is not covered yet. So any specific reason for that, or it is just the priority and the question of eligibility and the qualification? These 3 were the first to qualify for the requirements and they were granted.
Well, maybe I'll just kick in, and then if Sayesha, if you like to add any words, please feel free to do so. I could not really analyze the exact reason or the cause of the geographical I would not say imbalance, but the geographical skew of the location of these IDAs. But as you already mentioned, certainly there is a requirement issues relating to it cannot be any cultural collection. Secondly, I'm not fully aware of the of the, let's say, geographical innovation activities in India, that oftentimes those cultural collections are associated with the university or research centers, which are very active in the biotechnology area. And so that might be also related to in terms of the innovation
yeah,
hub. Mhm.
I'll just interrupt you for a second. So the interesting fact is that the South India is the hub of research, and the
Oh,
India's topmost research institute, which is Indian Institute of Science, is located
mhm,
in Bangalore, which is in South India. Okay, so that is a very strange thing, because in Hyderabad also we have got a lab for molecular biology. So there are a lot of institutes which definitely adhere to those stringent conditions for being an IDA, and definitely they would qualify for it. But
mhm,
so the latest one, which is located in UP in Mau, which got the IDA status in 2020, is located in a remote village. Okay, and their patent activity is also not very high, and they are not affiliated to any university also. So this is very a strange kind of a
mhm,
recognition and affiliation, and kind of a you can say a kind of a facility provided, because that place is located in a remote area, so nobody have easy access to it also.
mhm. I see. Well, it is not WIPO who decides. It's not us to decide which institution has acquired the status of the IDA. As I mentioned, in order to obtain the status, it has to be the request has to be made from the government of India, and I do take your point, and maybe now, when I think about it, it's one reason could be possibly the awareness about the Budapest Treaty, or awareness about uh, the international depository authorities and the Budapest system. And I hope that this short webinar is going to raise your awareness, and then would be useful for the researchers in this biotech field, which their need might not yet be met through the use of the IDA. Is there any other questions or comments? Are also welcome. I know that it's very late in the evening, so maybe many people are quite tired,
Hello,
getting
excuse me.
tired.
Can you hear
Yes,
me?
yes,
Uh,
please.
so can you just explain how much fees we have to deposit? We don't have any general idea regarding when we are depositing any culture. You know.
I can take that question. I think if you're talking about submitting these biological material or deposits with the IDAs in India, as I had mentioned, and it was also available on our slide, our website basically has specific links to these specific sort of IDAs which are there in India, because for different microorganisms, there are different fees which are associated for making deposits, etc. So I'll probably do one thing after this. I will put those links in the chat, those specific links, and maybe then you can access those documents, and it'll be easy to sort of access and understand what are the fees for deposits to be made in these IDAs.
It is 20,000 Indian rupees for if you have to do a deposit with respect to a patent application.
Oh, okay, it was about the patent application. Okay, I thought about deposits to be made in the IDAs. So, but yeah, if that is the question, then that is the answer. But I will still put the links on the chat. Tomoko, is there anything that you would want to add?
Yes, I do try to open the open the page, but I'm not too quick to navigate the website yet. But certainly, as Sayasha said, it is all available on the guide. The guide on the Budapest Treaty. So please have a look at the link, and then you will find all the information, including the fee information. Is there any other questions?
Yeah, hi, this is Prabhat Sen, and I would like to appreciate your efforts. The session was amazing. And I want to ask one question, like, is there any PDF or any source where we can get the list of microorganisms that need to be deposited before the international depository? Like, I was always wondering, like, what is the microorganism, like, scope of microorganism or anything related to microorganisms that need to be deposited before the patent law or in the international depository. It would be much helpful for us, like if we have a source for that. Thank you.
Yes, definitely. That is the detailed information is available on this guide, the Budapest Treaty Guide, where there is also the fee information and everything is there. But there is also on the WIPO's website, which is called the Budapest System website, there is a database, a very easy or the very simple database, which gives you a quick idea of, okay, I need to deposit bacteria. Which IDA is going to accept bacteria? Then you can have a very quick search and get the list of the IDAs. And that kind of function might be something that you are looking for. And we will certainly put it on the chat.
Yeah, thank you so much. I got the link. Yeah, thank you.
Tomoko?
So, yes.
So what will happen after 30 years? Maximum limit is 30 years or what? For sample storage in IDA?
Yes, the storage of the deposited microorganism, it has to be saved in the IDAs for at least 30 years, or if there is any request for the 30 years from the 30 years, or if there is any request for a sample 5 years after the request of the sample, whichever is later. So it can be more than 30 years.
So what will the procedure of decomposing or what? After 30 years, how you will decompose that macro dispose?
Yes, so actually that is not stipulated in the Budapest Treaty, what happens after 30 years. So there are different practices made by each IDA. In many countries, that goes to the public collection. So there is this Budapest collection. So often they call it patent collections in their jargon. But then after 30 years or plus something expired, then that will be moved to the public collection. But it's not stipulated in the treaty, so there are different practices.
Thank you. It was very well session. We learned a lot regarding Budapest and Paris Convention. Thank you.
Thank you. So if there is no more questions, yes, I think then Mr. Kim is ready. And I will just simply pass the floor over to Tegun.
Thank you, Tomoko, and thank you also for his, the presentation, Sayasha and Tomoko. It was also a learning experience for me. Let me move on to our next session about the PCT Patent Cooperation Treaty. First of all, let me start sharing my screen. So I hope you can see this my slide, which reads the Patent Cooperation Treaty. And good evening, and again, and thank you for joining this seminar at this late time. My name is Taegeun Kim. Taegeun is my first name, and Kim is my family name, in case you wonder. But Taegeun is very exotic to most of the world, so you may remember me as Mr. Kim. Probably it will be easier for you. I would not recommend this speaker if I were in Korea, because there are millions of Mr. Kims, but there are not so many Mr. Kims in WIPO. So if you want to look for me, you can say you want to talk with Mr. Kim at the PCT. Following the presentation about Paris Convention, let me talk about the Patent Cooperation Treaty, which is also based on the Paris Convention. WIPO provides a number of global IP services. And yes, before I move on, let me remind you that you can ask questions in the chat box, and I will make sure to check them after my presentation, even if I cannot check it during while I speak. And this presentation is mostly about the introduction of the PCT, a basic level, but please feel free to ask any questions about the PCT in the chat box. So WIPO has a number of global IP services, and they cover various areas. And the Patent Cooperation Treaty, my topic today, covers, as the name suggests, patent, but not in a very strict way. I mean, other related similar rights, such as utility model, are also covered by the Patent Cooperation Treaty. And the Madrid system covers trademarks, Hague system, industrial designs, and the Lisbon system covers geographical indications. Geographical indications are such, those kind of things like wine in Bordeaux. If a French wine was produced in the Bordeaux region, it can be protected by making that kind of geographical indications. And the WIPO also provides some kind of arbitration mediations and a mediation service. Please let me remind you to mute yourselves if you have not, so that we do not have any noise during my presentation. And WIPO's Arbitration Mediation Center provides a hopefully more cost-effective and easier way in case of IP disputes. It mostly covers domain name disputes, but it is not limited to that. So let me move on to patent and priority claims. So to talk about the PCT, the Patent Cooperation Treaty, I guess the natural first step is talking about the patent. You may be knowledgeable about this and you may be not so much, but let me remind you about this basic knowledge of patent, which is essential to understand how PCT works. The patent is one of the industrial property rights, and it consists of a set of exclusive rights granted by a sovereign state for an invention. There are a number of items in this short sentence. It provides exclusive right. Exclusive right means that if you have a patent, you do not need to use it actually. Nobody forced you to use your patented invention. It's your choice, but you do have the right to stop others from using your invention without your permission. So you can exclude others from using it. So that's the idea of exclusive right. And this is not different from other kind of industrial property rights, such as trademark. And granted by a sovereign state. Yes, it should be granted by a national government, or at least a regional body which is recognized by a national government. A regional body such as the European Patent Office. So it is a kind of a sovereign right. It is granted by a nation or by states. And in other words, the right of the patent is territorial. This is one of the fundamental principles of the patent right. By territorial, it means that, well, simply say, let's put it in a simple way. If you have a patent in India, okay, you have the exclusive right, as I mentioned, in India, and you can stop others, your competitors, from using your invention. But it does not mean anything in Japan, for example. So it is strictly effective only within the given jurisdiction. That's the idea of territorial nature. So there is no world patent. One of the questions that we often receive from applicants or users around the world is that, why don't you just try to make up some kind of global patent so that we don't need to bother to get patent granted everywhere, before each government? But that's not how the system is built. And there is no such thing as global patent. And any patent right is effective only in the relevant jurisdiction. And by foreign invention, yes, the subject of a patent is an invention, a technological innovation. A trademark such as Coca-Cola is not protected by patent right because it is not an invention itself. But if it is a technology about the LCD, for example, a display, then it may be protected by patent right as an invention. And the protection is usually until 20 years from the filing date. Filing date is the date you submit your application to the relevant national regional office. And I believe I covered the exclusive right. So patent can be granted, and if you get a patent, you have this kind of exclusive right, in the relevant jurisdiction. Then, but patent is not automatically given. You have to file an application, and the application should be searched and examined by the relevant national or regional office such as the European Patent Office, national office such as your own Indian Patent Office. And according to each relevant national law, they examine your application, whether it is patentable or not. So based on the territorial principle, the patent criteria for patentability also varies across different jurisdictions. However, there are a lot of common factors in the patentability issue, and the PCT specifically deals with 3 criteria of patentability. The first one is novelty. I think novelty was mentioned during Sayasha's presentation. And novelty, once again, very simply put, novelty is whether your invention is new. New to what? Compared to the existing technology, already available technologies. And those available technologies, existing technologies, are often called prior arts. So yeah, it does not make sense if you are given the patent right when your invention in your application is something identical to what is already known or available. So yes, your invention should be novel to be granted a patent. And the second one is an inventive step, or it's called non-obviousness. I guess non-obviousness is a more intuitive term. It is a step forward from the novelty. So yes, your invention may be novel. It may not be the same with the existing ones. In many cases, in most cases, actually there should be at least some differences between your invention and the prior art, unless you intentionally copied prior art. However, it is just not enough if the difference between your invention and the prior art is not big enough. So it should be more than being obvious to a person skilled in the art. And this is the second criteria of patentability, which is an inventive step or non-obviousness. I used to work as a substantive patent examiner myself. And I can tell you that, probably lack of an inventive step is the most common reason a patent application is not granted a patent. And the third one is industrial applicability. Once again, for the purpose of this presentation, very simply put, it is whether your invention can be actually made and used in the real world. So in most cases, industrial applicability doesn't really become a big problem. So let's keep in mind those are three criteria of patentability, and let's talk about the right of priority under the Paris Convention. Tomoko and Ayesha very well covered this already, but I will repeat this in a more, how can I say, down-to-earth point of view, specific to the patent applications. So Ayesha mentioned that, yes, you should file an application within 12 months from the first application. But why? For what? So let me remind you about the patentability issues, patentability criteria. So novelty and inventive step, they are based on comparison of your invention to prior art. So when they compare it, it is very important whether those prior art were available to the public before your filing date, before you submit your patent application. If something, some competing technology was made available to the public after you file your patent application, it does not matter, it rarely becomes a problem to you. Your patent application was filed beforehand. So it is important to secure the filing date. The earlier, the better, as you would be able to expect. But in the real world situations where you want to file your patent applications in multiple countries, let's say that you have an invention and you want to get a patent right in India and also in Japan, for example. Then in Japan, probably you're from India, so probably you will file your first application in India. Yes, let's say that is the early first application. And what about the patent application in Japan? Yes, because of the territorial nature, your Indian patent application does not mean anything in Japan, and which means you have to file your application also in Japan to get a patent right in Japan before the Japan Patent Office. And as the novelty on inventive step, it is critical to secure an earlier filing date for novelty and inventive step. You file your Japanese application as soon as possible, or probably on the same date with the filing of Indian application. But in reality, yes, well, preparing a patent application is not an easy job. And when you file a first application in India, it is probably very difficult for you to file another application in Japan on the same day, on the same invention. You have to prepare the application in Japanese language. And it should meet all the formal requirements of the Japanese, under the Japanese law. And you probably need to hire an agent, local Japanese agent to all the prosecution before the Japan Patent Office. So it is impractical and well, practically almost impossible to file all the applications on the same day. And here comes the idea of right of priority. You have your first application in India. You do not need to file all the foreign applications on the same day, and you are given 12 months to do that for patent. So if you have your first application in India, from the filing date of that Indian application, within 12 months, you can file your secondary application in Japan before the Japan Patent Office in Japanese language, claiming priority of your earlier Indian application. So what does it mean? What kind of right is given in that case? In that case, when the Japanese examiner considers prior art, considers a novelty and inventive step, he or she takes that the secondary Japanese application as if it was filed on the same day with your earlier Indian application. That's the idea of the secondary point for prior art purposes. So not everything is calculated based on the earlier filing date of the Indian application. But for novelty and inventive step, which is the most important ones, the patent examiner in the secondary country will consider your application as filed on the first filing date in India. That's the right of priority for patent protection. So it is also possible to claim multiple priorities, which means that your Japanese application may claim priority of more than one Indian application, or it may even claim priority over one Indian application and another Korean application, for example. And the partial priority is also possible, which means that basically your secondary Japanese application would be almost the same, have almost the same content with your earlier Indian application. But it does not necessarily mean that they have to be 100% identical. And your Japanese application may have some subject matter which was not in your earlier Indian application. This is partial priority. In such cases, for those claims which were in the earlier Indian application, right of priority is applied. But for those inventions not in the earlier Indian application, the right of priority is not given, and the Japanese patent filing date will be the date the examiner will consider. Well, but to be granted the right of priority, I guess it is very obvious that they should be on the same thing. They have something in common at least. So if the first Indian application is about the car, and the second application in Japan is about ice cream, for example, it does not make any sense to give a right of priority in such cases. And after you file the first application properly in India, what happens to the Indian application does not really matter to the right of priority for your application, secondary application in Japan. So it is possible to even withdraw the early application in India. But as long as it was properly filed at the first day, on the first date, the right of priority for your Japanese application is effective. And yes, this is another question we often receive. You filed the first Indian application, and you filed the second Japanese application claiming priority of the earlier Indian application. And the Indian Patent Office, you are not so lucky, and Indian Patent Office refused to grant the patent on your earlier Indian application. In such cases, what happens to the Japanese application? Nothing. Even though the early application was refused, the right of priority is still effective, and the Japanese examiner will still consider the date of your earlier Indian application when they decide a novelty or inventive step. But still, but that's the idea of the right of priority under the Paris Convention. But in practice, if there is a reason the Indian Patent Office refused your earlier Indian application, and if the same reason is in the Japanese application, then you must be cautious, because Japanese patent examiner may reach the same conclusion anyway. So this is the idea about the patent and the right of priority under the Paris Convention for patent. PCT is a new treaty, younger than Paris Convention, which is more than 100 years old. PCT is a little more than 40 years old, I believe. However, PCT is not something entirely new, and it is still based on Paris Convention, especially about the right of priority. This is a diagram showing the traditional patent system, or we often call it Paris route, because it is a foreign filing route based on the Paris Convention. So this is just a picture saying it a different way of what I have already told you. You have the first application in 0 months, and by 12 months, you file each national or regional application in the respective jurisdiction. So I gave you an example about the earlier Indian application and the secondary application in Japan. But the secondary application, jurisdictions may not be only one. You may want to get patent also in the United States. Then it means by 12 months, you have to file the secondary application in Japan before the Japan Patent Office, and also in the United States before the United States Patent and Trademark Office. So this is the traditional way. You are given 12 months, but still you need to file individual applications before each relevant national or regional office. And when you do that, you have to meet multiple formality requirements. For Japan Patent Office, you have to provide some specific forms governed by Japanese law. And in the United States, the American law for the same. And each office, such as the JPO, the Japan Patent Office, and USPTO, United States Patent and Trademark Office, do the multiple searches for prior arts and multiple examinations based on their each own respective national law. And there are also multiple publications. A publication is an essential part of a patent system. The basic idea is that your application will be made available to the public so that everybody can see. That's the price of trying to get an exclusive right and to promote technological innovation based on your achievement. But that's, well, let's say that that's the price you have to pay when you use the patent system. But for this kind of traditional Paris route, USPTO and the JPO will make publications of your application respectively, separately. And all those national costs. Yeah, if you file in Japan, you have to pay some office fees for the Japan Patent Office, and you have to translate your application into Japanese language, which is often very costly. And you will probably would have to hire a local agent. And all those costs should be prepared and they are incurred by 12 months under the Paris route. So Paris route and the right of priority works very well. Actually, well, it has been it has stood its test of time. It's more than 100 years old anyway. And it is a it is a system working very well. But especially when you want to file in multiple jurisdictions, foreign jurisdictions, it may not be very convenient to use. Therefore, they entered the idea of the PCT, the Patent Cooperation Treaty. As I told you repeatedly, PCT is not entirely new thing, and the priority of a PCT application is also governed by the Paris Convention. It is built based on Paris Convention. But the difference is, instead of filing all your applications in all the relevant jurisdictions by 12 months individually, you need to file a single PCT international application by 12 months. Yes, it's also 12 months because it is a priority under the Paris Convention. However, you need to file only single PCT international application, and you have more additional 18 months in most cases. And by 30 months from the date of your earlier Indian national filing, you need to decide which country you will enter into. So after that, after the 30 months, it is not really different from Paris route provides, but you do have some additional time. And under this, in this PCT timeline, from the filing of PCT application to the date, to the time of 30 months, when it is called entering the national phase. This period between 12 and 30 months is called international phase. And after 30 months, you do get examination and prosecutions by each national and regional office, and it is called national phase. This is the overview of the PCT system in terms of flow of documents. Yes, you have an invention and you want to file a patent application. You may have your first application in India, but also it is also possible for you to file your PCT application directly with your invention. It's your choice. But in most cases, we find that applicants have earlier national application and file PCT applications claiming priority of that earlier application. Anyway, you have an invention and you want to file an international application. So where are you supposed to file the international applications? With the Paris route, it is very obvious. If you want to get a patent in Japan, you have to file it with the Japan Patent Office. But in PCT, if you have to file only a single application, where should it be? It is called a receiving office. I think that some terminologies under the PCTs are very straightforward, and they didn't really think twice to come up with the names. And the receiving office is often an office receives application and the fees. And who is this receiving office? Actually, national regional offices function as receiving offices under the PCT. So in your case, there are two available receiving offices. If you're national or resident of India, you can use the receiving office of India, ROIN, as it is actually Indian Patent Office, and legally speaking, it is working as a ROIN under the PCT. So otherwise, you can also choose to file with ROIB, the Receiving Office of International Bureau. International Bureau is here, here in Geneva at WIPO. But the International Bureau itself is should be distinguished from Receiving Office of International Bureau. International Bureau is for all the applications go through International Bureau, and the International Bureau does some roles on international applications. We have a team within the IB, the International Bureau, called the ROIB team, and it also works as a receiving office, just like a receiving office of India. As from my knowledge, I think Indian applicants very often use ROIB as well as ROIN. And when you file your application with this receiving office, one of the available receiving offices, you cannot just submit your application both to the ROIB and ROIN. You should choose one. And then the file is transmitted both to the International Bureau and also to something called the International Authority. So yeah, for the purpose of today's introductory presentation, I will just focus on ISA among IAs, because SISA, Supplementary International Searching Authority, or IPEA, International Preliminary Examining Authority, their procedures are entirely optional. They are applied only when you choose to use them. And to be honest, not many people use them these days. But ISA procedure is for all applications. ISA stands for International Searching Authority. As I said, some PhD terminology are very straightforward. What does ISA do? International search, as its name suggests. Search for what? Search for prior art. So ISA, when they receive your the so-called search copy from your application, they do the search for prior art, and they issue a report with what they came up with a list of prior art. It is called International Search Report, and they also attach a written opinion about their view on the patentability of your application. However, one thing you have to remember is that this International Search Report and the written opinion of the ISA is non-binding. It means that, yes, the territorial nature of the any patent right applies even through the PCT. And in this diagram, to the rightmost part, there are something called the designated offices. So designated offices, national or regional office, you enter into the national phase. So if you have filed a PCT application, and if you want to get a patent in Japan, then you have to enter the Japanese national phase by 30 months from the earliest date of filing of your Indian application. If there is a priority claim, we call it priority date. So by 30 months from the priority date, you have to enter the Japanese national phase. And after that, it is all up to the JPO, the Japan Patent Office, whether they will examine your application according to the Japanese law. And it is entirely up to the JPO whether they will grant patent on your invention or not. So ISA's opinion, even if it was positive, the JPO may find it a different way and may decide to refuse your patent, and vice versa. If the ISA was negative, the Japan Patent Office may come up with a positive result and grant you patent. So that's why I say the opinion of the ISA is non-binding. However, in many cases, the ISA results, even if they do not bind designated offices, provide some good insights about the patentability of your invention. And after they issue the international search report, they are also sent to the International Bureau, to us, and the WIPO as an International Bureau published the international application with the international search report at 18 months from the priority date. And we do it online these days, and it is on a website called Patent Scope. So it means that if you go to the Patent Scope website, you can see all the published PCT international applications. And by 30 months, and in some offices it's 31 months, for example, for the EPO, you need to choose which jurisdictions you will enter into, and after that, it is a national phase. So when I talk about the international search reports, I often find that people wonder how it looks. You may be familiar with it, but you may not be not. So this is an example of the international search report. It may look like some kind of complex table, but it is actually not. And it just lists prior art in the center column. For example, JP 5015143535B is a Japanese patent document. And it means that if you consider this Japanese patent document, your invention in claims 7 to 9 and 11, please see the right column, may be denied novelty or inventive step. That's the meaning of the category X. So this is how the International Searching Authority shares their outcomes to you. This diagram is just the same thing with what I have shown in 2 slides before. It's just based on the timelines instead of a document flow. Yes, you have at 0 months, you have the first application. In my example, from India, and you have to file a PCT application by 12 months, according to the right of priority under the Paris Convention. And between 12 months and 30 months, there are a few things happen: international search and international publication. The others are actually optional, so I will not cover it now. And by 30 months, you have to enter into the national phase. So this is the idea of the PCT system. So basically, it's like a Paris route, but you need to file only a single application by 12 months instead of filing all different applications in all different countries. And you are given additional time frame during the international phase until you choose to enter into the national phase. However, after entering the national phase, it is still just like a Paris route, up to each national or regional office to decide whether your patent invention can be patented or not. Territorial nature, once again. Local patent, yes, I believe I explained most of this. One set of formality requirements, instead of preparing Japanese patent application and US application, you need to just prepare a PCT application according to the given form. And there are intention search and publication. And there are also some optional procedures, such as preliminary examination, if you want to pay for them. And, yes, the last bullet point is probably important. Translation and national fees required at 13 months, and only if the applicant wishes to proceed. So this is one of the major differences and major advantages of the PCT system, actually. For Paris route, you need to decide everything and pay all the national cost at 12 months. But for PCT system, you can do it, however, you should still decide where you will enter, and you should also pay a lot of national or regional costs, but it can be postponed up to 13 months. And if you decide that you don't want to go into national phase of any country, then you can just can just do nothing and nothing happens. You may wonder why would anyone want to do nothing after filing the application and paying all the fees for PCT filings. But yes, one example is that, yeah, that's one of the advantages of the international search. Even though the international search outcomes are not binding, let's say that you have received an international search report, and even you have to agree with the ISA examiner that your invention is not really patentable. You have no hope. Well, I'm sorry to say that, but it happens. But in such cases, at least you can just stop caring about your application and save money, which may have been charged on you, may have been save the money which have been maybe have been a very big cost for translation, for example, in each country of your interest. There are two ways. One minor, not minor, but one point you may want to remember is that, yes, I tell you that you do not have to do anything if you are not interested in getting a patent. But if it is before the international publication, and yes, let's say that you decided to give up, you do not want to pursue any patent with your PCT application, then in that case, you may want that nobody to see your application. In other words, you may want to prevent international publication. You are not getting patent from this anyway. In such cases, you need to withdraw your international application in advance of the international publication. It should not be done now, just the previous day of the international publication. It should be given at least 15 days. But if you do that, to withdraw your application with enough time before the international publication, then the International Bureau will not publish your international application. However, if it was published already and you still do not want to go into any country, you can simply do nothing. You do not need to do anything. So the PCT system is a patent filing system, as I have explained. It helps you file your patent applications abroad, especially if you are interested in a lot of jurisdictions or countries and states. But it is just a filing system, and it is not a patent granting system. Grant of the patent is still always up to each national or regional office. So there is no PCT patent. There is only PCT international application for patent. So there is no PCT patent. There is no world patent. There is no global patent. There is no such a thing because of the territorial principle. And I believe I covered the second bullet point already. And the inventions are protected by the PCT, and the trademark and industrial designs, for example, are covered by other similar international filing systems provided by WIPO, namely Madrid, The Hague systems. But once again, it is not only in a narrow meaning of patent. Similar rights, such as utility models, can be covered by PCT. So this was a basic summary of the PCT, and especially in particular compared to the traditional Paris route, and what is benefit of using the PCT. I think I covered most of these already. You need to file one application in one language, filed with one office, and it has the effect of filing multiple foreign applications if you choose to enter those national phase. And it permits last minute foreign filing. Let's say that you are at, you have the first Indian application, and you are at 11 months and 28 days from its earliest filing, from the earlier filing date. And you suddenly decide that, oh, I want to get patent in Japan. So you have 2 days to file your application, prepare and file your application in Japanese language under the Japanese law for the Japan Patent Office. I guess that you understand that this is not really easy, but even in such cases, you can just file the PCT application. It does not need to be in Japanese language. It can be in English. File your PCT application to the receiving office, and then you can enter into the Japanese national phase afterwards. Still, it is not recommended to wait until the end of the priority period or the 12 months from the earlier filing date. But for some reason, we find that most agents and applicants file the secondary applications or PCT applications at the end of the priority period. And the international filing date has the effect of national filing date in all designated offices. So let's say that you have your first application and in India, and after 1 year, after 12 months, you file the PCT application and you entered into the national phase in Korea, my home country, after 31 months. South Korean office actually provides 31 months instead of 30. In 31 months, then you are lucky that you got the patent in Korea. So I told you that the patent protection term is counted from the filing date, and it is more 20 years in most countries. Then from what date do you count these 20 years? Is it from for the Korean patent I mentioned? Is it from the date of your Indian application? Is it from the international filing date of the PCT application? Or is it from the date of national phase entry into Korea? It is from the date of the international filing date, the date you submitted your PCT application to the receiving office. The right of priority is only for prior art purposes, for decision on novelty and inventive step. The advantage of 12 months is given only for that, and other legal calculations based on the filing date will be based on international filing date. And the uniform formal requirements accepted by all designated offices. Yeah, when you file your PCT application and you enter into national phase of designated offices, you are not supposed to provide any additional form, and you just need to provide translations if necessary. However, this PCT principle does not, this PCT principle means that designated offices cannot force you to submit some different forms not specified in the PCT, but if actually there are many designated offices asking for certain forms upon national phase entry. And in that case, even though they are not mandatory, they cannot stop your application and you do not submit those unique forms, but you are recommended to follow the recommendations by each designated offices, because in practice, it will actually help a smooth projection of your application. But in principle, what I'm saying is that in principle, designated offices cannot stop you just because of not meeting some unique formal requirements. And the greater home control of prosecution, yes. You would be able to assume that, guess that controlling the Japanese patent application from India would not be easy, but at least until the national phase entry into Japan, you can control your PCT application from India, and you can even use Indian patent attorneys or agents as agents during the international phase. And the decision on foreign filings can be postponed up to 30 months from the priority date at minimal cost, and it enables assessment of economic value of the invention and the chances of obtaining a patent before entering national phase Those last two bullet points are connected. And this is actually the reason we often hear from the big PCT users why they use PCT. They can earn more time. Yeah, well, even though I am working on for the PCT, I do not say lie, and PCT is not always the best option. In some cases, Paris route could be better. For example, let's say that if you have an Indian application and you want to get patent in Japanese jurisdiction, in Japan, and you are absolutely sure that you want to get patent in Japan and only in Japan. You are not interested in any other country for some reason, and you want to get a patent in Japan as soon as possible. In such cases, you do not need to use PCT route, and you can just file your secondary application directly to the Japan Patent Office under the traditional Paris route. It would be faster and more cost-effective. However, in most cases in the real world, you're not sure at the beginning. You do not know which markets will give you more income afterwards. So you may want to see and secure some time to see that. You may want to see how your competitors do in the US market, for example. And then you may want to see if there is any similar product coming up in the Japanese market, for instance. So PCT gives time to do that for you. And as a bonus with the international search report, you may also have some preliminary view on the patentability. Yes, as I mentioned earlier, if you think that it is not really your invention is not really patentable at all, then you can save the cost of entering into national fees of Japan and United States, in my example. So all these points considered, yes, the applicants should choose between Paris route and PCT route. I explained this already. And the choice of receiving office. You have two receiving offices available, ROIM and ROIB. And not only the receiving office, the international searching authority should be chosen. There are more than 20 international searching authorities, but not all of them are available to you. But if you are a national resident of India, I think the available ISAs there are Australian, Austrian, Chinese, EPO, the European Patent Office, Indian, you own, JPO, Japan, Swedish, and USPTO. So you need to select one of those ISAs, and those what you should consider when choosing the ISA is that yes, surely their quality and reputation, but also the acceptable language and search fees. Yeah, the cost is different across ISAs, and it is one of the important factors when you choose the ISA. And after that, you need to decide whether to proceed with or drop the international application. And if you are to drop the international application, whether you will withdraw the application to prevent international publication, or you just don't care and leave it. And the last one is also important: where to enter the national phase. Yes, in my example, I gave you Japan and the US, for example, but you need to decide these based on your business and commercial need for exclusivity. In other words, whether you need a patent in Japan. And initial and long-term cost. Initial cost is the cost you need to pay to get your patent. For example, office fees and the translations and the agent fees. But there are also long-term costs in many countries, in most countries, I believe, actually. After being granted a patent, they ask you to pay annual or once in 3 years, for example, pay quite a big amount of fees to keep your patent right. So patent protection is usually 20 years from the filing date. But if your invention is in a very fast changing industry and your invention will be outdated in 10 years, for example, then you may not want to maintain your patent for the entire period of 20 years. and the status of patent systems and potential for enforcement of any rights obtained. So patent right gives you an exclusive right. It allows you to stop others using your invention, but it is worthwhile only if the legal system of the country is working well, and you can expect that there will be enforcement, and the court is working in your favor, so that you can sue, for example, your competitors for infringing your patent right. But in some countries, unfortunately, the system is not, enforcement system is not really working well, and in such cases, it might not be worthwhile to pay the cost for patent protection. So this was the main part of my presentation, and I will move on to a more light part, which is the current status of the PCT system. So there are 156 contracting states. Cabo Verde recently joined us and will be bound by the treaty by the PCT from July of this year, if I'm not mistaken. So yeah, just like the Paris Convention, it covers most areas of the world. However, yeah, there are still countries which are not part of the PCT. Some of them are, I think, many of them are actually from South America, but you can safely say that most of the biggest world markets are covered by the PCT system. The PCT has been very successful since its launch in 1970. The number of applications has been growing, and actually it is the major source of income for WIPO. You can see that there was a little minor setback during around 2009, and it was during the global economic downturn originated from the United States. But besides that, except for that, PCT filings and PCT usage has been growing continuously. It has grown even during the COVID-19 pandemic. And who are using this PCT system? Well, China has become the biggest PCT filer from a few years ago, surpassing United States, and it's followed by US, Japan, and Republic of Korea, Germany. And now more than half of PCT applications are filed in Asia, and India is one of the big PCT users with almost 2,000 applications a year. So this introductory session may have suited you, hopefully suited your needs, but it may not be. But in such cases, you may want to seek more in-depth courses, and we do provide them a lot actually, all for free. And you can find this information available on the internet. And we do provide something called the PCT Applicant's Guide, which you can find all the information you may need to when filing a PCT application. For example, I told you, I listed you the available international searching authorities for the Indian applicants. And well, yeah, I don't remember all those lists of ISAs for all countries, and I found it from this PCT Applicant's Guide. And if you want to learn more, there is something called Learn the PCT video series. You can see it for free, and it covers in depth from the filing stage to the national phase entry, everything of it. And we do provide also distance learning course. And we also provide free PCT webinars. Well, let me be shameless and advertise this. We also have another PCT webinar on Thursday, 3 o'clock in European time, which will cover a more specific topic about the PCT Article 19 and 34 amendment, as well as rectification of obvious mistakes under Rule 91. But if you are interested, or if you are interested in seeing previous webinars, they are all recorded and uploaded on this webpage about PCT webinars. And you can access all of them, both the presentation materials and the recorded videos for free. And if you have any question about the PCT info line can be your first choice of contact at WIPO. PCT info line covers everything about the PCT. It could be a general question. It could be a specific question about a specific application. My colleagues at InfoLine will give you an answer immediately, or at least forward your application to the relevant colleagues. And if your question is more about the internet IT systems, such as ePCT, you may want to contact PCT e-services. And now you have seen my presentation. Yes, in case you have any question about the PCT, please feel free to write to me at my email address. This is all about my presentation, and thank you. And before I invite you for the Q&A, let me check the chat box first to see if there is any question. Yes, you want to have this presentation through email. Well, for my case, I think I can. I don't mind sharing it, and maybe I will send my presentation material to the local organizer. I'm not sure if they can share it with you, but if not, maybe you can email me, and I'll be happy to send my presentation material. And the next question is, in the case of PCT, how opposition to pre-grant and post-grant done, same as being done to local patent applications procedure? Yes, for the national patent or regional patent applications, yes, you often get if the office finds that your application is not patentable, they will give you at least a letter, which is often called first office action or FA, and then you have a chance to reply to that or amend your application. I'm talking about the national application, not PCT. And even after granting, patent right granted, third parties may oppose to it, to an appeal body in many countries. However, under the PCT, there is basically no such thing because PCT does not grant you patent in the first place. ISAs give only the non-binding opinion, which may be taken into account by the designated office afterwards. So there is no formal opposition or appeal procedures under the PCT. However, it is still possible to provide some informal comments if you are not happy about the outcomes provided by the International Searching Authority, for example, or it is also possible for a third party to provide some observations about some PCT application. You may think that, oh, there is a PCT application by my competitor and it should not be patented, and I have a very good prior art to do that. Then you can use something called the third-party observations. For the third-party observations or informal comments, they are rather informal procedures. If you see I think the PCT applicant's guide in my presentation, which was mentioned in my presentation, has some information on that, how to do that. But if you need any further information, you can email me anytime. But in principle, they are just informal procedures, and there is no formal opposition or appeal procedures because there is no PCT patent at all. And what's the difference between the elected office and designated office? Yes, I did not mention elected office during my presentation because I did not cover International Preliminary Examining Authority, IPEA. As I told you, designated office is the office you enter into the national phase with. Yes, you have filed your PCT application and you go into Japan, and Japan Patent Office is a designated office, or DOJP, as we call it. And what is the elected office? If you file a demand for international preliminary examination, which is entirely optional, if you file a demand, then Yeah, it is actually remainings of the old PCT system. If you file the demand for the international preliminary examination, the offices which take into account the results of the international preliminary examination are called elected offices. So elected offices are not really different from designated offices, but the difference is that elected office, for example, the Japan Patent Office, JPO, is called EOJP if they take into account the outcomes of the international preliminary examination. But under the current PCT system, when you file a demand for international preliminary examination, you can safely understand that all the national offices will take that into account. So in practice, there are little difference from between designated DO and EO, but legally speaking, EO, elected office, is those national regional offices taking into account the international preliminary examination outcomes. So these are all the questions from the chat box. So let me open the floor for you to speak up and ask me questions about the PCT. So I am not sure, but it's almost, yes, I guess it's 11:20 in India, and maybe it's a bit too late to keep you for too long. So if there is no question, yes, I think I should not keep you from going to bed now. And thank you very much. Thank you again very much. Oh, yes, please.
Thank you, sir. Thank you,
Yeah,
sir,
thank you.
for today's session. I think there is no question, so we can end the session within some minutes. And also, I want to say thanks to Ms. Tomko and Ms. Saisha for today's session.
Okay. Thank you very much. And once again, please feel free to email me with any question about the PCT. Thank you.
Thank you.
Okay, I wish you all good night, and I'll leave. Bye.
Yeah.